If you spend any time in courts here in Massachusetts, then you're going to realize very quickly that many lawsuits result in default judgments. This is when one side fails to appear or answer the complaint that starts the lawsuit, and the other side, typically the plaintiff, wins without going through a trial. This is particularly common in small claims and maybe even in some district court matters where the amount in controversy is not high. For whatever reason, the defendant will just think if he ignores the complaint and the court paperwork that everything will just go away. It doesn't. The plaintiff will win by default, and then he will have an execution to put a lien on your property or to start trying to collect money from you. So defaults are granted pursuant to Civil Rule of Procedure 55, A and B. Now, if a default judgment has entered against you and you want to ask the court to remove it, typically they will, and you'll make a motion pursuant to Rule 55C, which states, quote, "For good cause shown, the court may set aside an entry of default, and if a judgment has been entered, may likewise set it aside." So in other words, if you've defaulted, if you haven't answered a complaint, if you haven't shown up for the legal proceedings, and the judgment has entered against you, if you could present the court with some good cause for why you failed to answer, the court will set aside the judgment and let the matter go forward and be determined on the merits through litigation. So if you're involved in litigation, if you've had a default judgment entered against you, or if you just have questions about this or comments, feel free to leave a comment or to send a message to me, and I'd be happy to talk with you.